Welcome, ladies and gentlemen. In just a moment, the court will begin the unlawful detainer trials. Before doing so, we would like to give you information which may help you understand the process. Although trials in unlawful detainer cases may appear less formal in some ways than other Superior Court trials, the same rules and procedures apply. Therefore, you should listen carefully to this information. An unlawful detainer trial is limited to certain issues. The main purpose of an unlawful detainer trial is to determine whether the tenant has the right to remain on the property or must move out. You should let the judge know in the beginning if the tenant has moved out with all belongings. There may be other disputes between the parties which cannot be resolved in this unlawful detainer case. Those disputes might have to be resolved in a separate trial. Today is the day for your trial. If there is a reason why you cannot have your trial today, you should tell the judge in the beginning. You must have a very good reason to delay the trial if the other party does not agree. The trial is the only time for you to explain to the judge why the case should be decided in your favor and to prove the facts supporting your position. Generally, the landlord must prove the facts stated in the complaint, and the tenant must prove the facts stated in the answer. The court will not treat a statement made in court papers as true unless the other party has admitted the statement is true or the evidence shows that it is true. Typically, the landlord must present his or her side first. This is because the landlord has the burden to prove the basis for the landlord's claim. When the landlord is finished presenting his or her side, the tenant will have an equal opportunity to present the tenant's side. Evidence is used to prove facts and can take many forms. One common form of evidence is in-court testimony from the parties or witnesses. Evidence can also be in the form of documents and photographs, and there are other kinds of evidence. There are things which the court cannot consider in deciding the case. The law describes the things which the court can and cannot consider. Each side has the right to object to evidence presented by the other side if it is not proper. This applies to all types of evidence, including court testimony, documents, and photographs. Objections must be based on the law. If you want the court to consider a document or a photograph, you should be prepared to show that it is a fair representation of the thing it shows and that it is relevant and reliable information. Witness testimony is often taken by questions and answers. Questions must be in a proper form to be allowed. For example, lengthy statements or arguments made in the form of a question may not be permitted. Questions which are short and simple are often the best. Each side has the right to ask questions of anyone called to testify by the other side. This is called cross-examination. The judge will not be calling any witnesses or presenting any evidence. That is the job of the parties. Although the judge may ask questions of a witness to clarify certain points, it is the responsibility of the parties to ask the questions required to prove that party's case. If the judge does ask a question, you may object to it if you feel it is not a proper question. A tenant may defend an unlawful detainer case by showing that the landlord has not proven the landlord's case or by proving a defense which would allow the tenant to remain on the property. However, a tenant may only raise defenses which, if proven, would allow the tenant to stay on the property. After each side has had an opportunity to present evidence, the court will make a decision. The court's decision is called the judgment. Each party may have the right to enforce, delay, or challenge the judgment. Those matters are not discussed here. Any party with questions can visit the court's Self-Help Legal Access Center or seek legal advice from a private attorney. The parties may want to settle their case before the trial starts. There are advantages to a settlement. First, if you reach a settlement, you know how the case will be resolved. Second, the parties can agree in a settlement to terms which the court could not or would not order. For example, the parties may agree that the tenant can stay on the property for a limited time. If you reach a settlement, please let the bailiff know. Also, if you are discussing settlement when your case is called, let the judge know. In just a moment, the court will begin the trial of your matter.